Welcome to SLA Spotlight, the podcast of Stuart Leach Associates, the litigation and disputes communication specialists. I'm Malcolm Monroe, a journalist, and in this series we'll be talking to leaders, thinkers, pioneers in the world of law, business, media, sport, arts, and much more. Today I'm joined by Noor Kadhim. Noor, welcome.
Thank you.
Perhaps we can begin by just talking about your journey, if you like, from an interest in the arts and heritage to the much more complex areas of international law.
Or law generally, because I didn't actually think I would be a lawyer. See, in my family, you're either a doctor or an engineer, or in the case of my parents, architects. I was accepted into architecture school, and I was stood at the postbox thinking, what shall I choose? And I chose law because I love writing. And I obviously had to do something with the high grades I got because my family would be upset. I didn't actually ever think I would continue to be a lawyer. But as you said, the world in which I found myself, international law and disputes, is complex but also very exciting. So I did stay. And so I have brought the creative aspect of my character to the law.
Yes, but architecture is very, very different to law. What did your family think about that?
My father was very happy and very angry at my mother for dissuading me from architecture. He wanted me to be an architect. My mother said a word which I didn't quite understand at the time, which was recession, and she said, architects in recession, and you're not going to do very well. Lawyers will do well. I said, I don't like the sound of recession, and I don't like the sound of, a world in which it's very competitive and subjective. So I'd rather study for exams and do well and write and become a lawyer. So they were both happy. I mean, I think your parents are just happy if you're doing something that you end up liking.
I guess there are similarities in the sense that law requires structure, it requires forward thinking, it requires vision. Do you see some of those comparisons?
I wish I had more structure. I shouldn't be saying this because my clients will be thinking, my goodness, have we chosen the right lawyer?
Oh.
But I should.
Okay, well, I'll ask that question again and say, well, of course, there are similarities, aren't there, between architecture and law in the sense that they both require structure, planning, long-term vision. Mm-hmm. Do you see some of those comparisons?
Yes, I do. I see that. I think that we are all constructing something. And actually, I think we didn't mention this field, but we're also all salespeople. And we know we need to have people skills. And I think, whether you're on site as an architect, meeting people, working with engineers and clients, or whether you're a lawyer, working with your clients, you do have to have these skills, communication skills, which is very relevant for this podcast we're in. Communication skills are important, and especially so for lawyers, I think.
Well, yes, of course. And you have worked internationally. You've worked in other jurisdictions, such as Abu Dhabi and elsewhere. What have you learned from operating in different jurisdictions where the rule of law isn't necessarily based on the same principles? And how do you find adapting to those different areas of the world?
I've worked in France, I've worked in Dubai, I've worked in Abu Dhabi, different from Dubai. People from Dubai will tell you in Abu Dhabi, vice versa. I think that culture is very important. So I have, obviously those different working experiences. I mean, from a young age, because my first traineeship, I spent time in Paris, in the Paris office of the firm that I worked for. So from a young age, I did travel. You have to understand that, when you're in Rome, you do as Rome does to an extent. So it's not just the legal structure, but the cultural framework that one must adapt to. So I learned different things about being in Abu Dhabi, being in Dubai. How do you approach business? When you go into a meeting, how do you conduct yourself? Do you go straight into talking about the business transaction, or do you spend time as you do in the Arab world where you're from? I mean, I'm from Iraq originally. I was born in Baghdad, left at the age of 4, and grew up in Scotland. So I have a Scottish aspect to my character, and obviously that's my home, and my parents are from Iraq. So when you're in an environment such as in Dubai, for instance, you understand that you cannot go in with an Anglo-Saxon approach of, okay, right, let's just get to the schedule. Okay, we're going to do this business transaction. We're going to sign on the line. You've got to ask about your client's family. In one case, in relation to a Qatari case, we spent about half an hour talking about camels. And the client owned camels, got really, really excited about his camels. And half an hour went by. I think somebody next to me just come out to the region said, when are we going to talk about, his arbitration? Yeah. I just said, just patience, because there are things that you need to understand. Of course, when you're in the States, and I've traveled a lot to New York, it's different. You go in, there are no niceties. It's okay, let's get on to this. What's the price? Are we going to do this deal? That's even a faster and even more, let's say, capitalist commercial environment than even in the UK. And I think being in the UK is great because it's the midpoint. It is not so, American capitalist, let's make Britain great again type. I'm not going to go there. I said outside some.
Okay, let's just stop there for a second, because that was a really good answer.
Yeah.
I committed a cardinal sin, which I'm so ashamed, is I had my phone on, which I absolutely should not have done. So I'm switching that off. That was a great answer, a really good answer. Sorry about the ping. But then obviously we'll come out of that a little bit early.
Yes.
So let me give us a bit of an edit on that, so come out of it. So I'll say, I'll, if you like, I'll jump in, so it'll help us through that last little bit. So what you're really saying is that whilst obviously there will be different rules of law in different parts of the world, perhaps more important than that is the human side of it, recognizing different perceptions.
Yes, absolutely. Very much so.
Okay, well, tell me about, you founded Kadhims, your own consultancy. That in itself is a whole new ball game, if you like. Why did you decide to, if you like, run your own business, be the founder of your own business, and what have the challenges been around that?
Yes, I think that many people could go different ways in the COVID era, where we had a lot of time to think about what we wanted to do. And I think that I reflected and I thought, I'm a person who has worked for many different entities. I've worked for boutiques, I've worked in-house, international law firms, and I've always been an independent person. I have never liked to be tied down or be told this is the way and there is only one way of doing things. And I like to have the ability to manage and to business develop. And I've always found previous roles slightly frustrating. I wanted to set up an organization, and I'm not unlike many lawyers, I'm not averse to taking risks, because it is a risky business setting up your own company. So you need to have a couple of good clients and then think, right, I'm going to be fine. And I wanted to set up my own firm because I don't think one firm caters for everything. And so I would rather be a nimble player that is able to work with people I know and trust on different disputes that require different teams than in one place. And I remember an ICC conference whereby a barrister, I think it was Vernon Flynn, KC, said just something that stuck in my mind. I'm a speedboat, not a cruise liner. And that just stuck in my mind. I'm a speedboat, not a cruise liner. I like to go to whatever island I decide in my business, and that is the essence of Kadhims.
Interesting. Now, as I understand it, your approach could be different perhaps than some practices, in the sense that you're very interested in where it's possible litigation avoidance or dispute avoidance, and sometimes would you advise clients that actually, to pursue a costly dispute isn't necessarily the right way forward?
Yes, I think for some clients, it's not also about money. They want to establish it's a pride thing. It's a proving a point thing. I think, though unfairly in our industry, especially in arbitration, in order to be able to have an arbitration, you need to understand it will cost you a lot. So even if you have a very meritorious case, the flinging money at it, you might end up losing much more, obviously, financially. So it's prohibitive. I think that one has to proceed always with caution when entering into an adversarial dispute position. I think that the best strategy, if at all possible, is to come to a negotiated outcome, whether you're in a family law situation such as a divorce, and I'm not obviously that's not my specialism. You want to avoid the lawyers, or whether you're in an arbitration where can you get to a settlement. So my goal, and including with Kadhims, is to try to get to that, minimize the damage, get to that settlement that is good for all. That's not necessarily the outcome that many big firms operate by, even if they don't say it out loud. More money is made by, sending high bills, and it's not in the interests of a firm.
Well, certainly that can be the perception. I'm sure in some cases it's an unfair perception that, for lawyers, if you can spin things out a bit, get involved in a long and protracted dispute, there's probably more margin in it and more profit in it. But actually, the best advice can often be to avoid that.
Yes, or employ certain routes that may get you there quicker. I mean, I had a recent client who was frustrated about a debt not being paid. I said, hang on, does this company care about its reputation? And we care about reputations. This is why we're here. We talk about reputation. How about if the debt is above a certain amount, just apply to wind them up? I mean, rather than that, and so they paid the next day. I mean, they are not going to go through that embarrassment. So again, you can still use the law to your best, ends. It doesn't have to be that which you were trained to do, such as let's go through a whole entire arbitration. Are there other pressure points you can do? And I think people do care about their reputation in most disputes.
Well, this raises a really interesting point, which, plays to the whole world of dispute and litigation communications as opposed to taking it through the courts, is that very often people are concerned about their reputation, sometimes as much, if not more, than the actual outcome of the dispute. And do you think that the whole world of how you communicate a dispute, be it within a court of arbitration or a courtroom, or through the media or through other public platforms, can be just as significant as the legal process?
Yes, of course. And one has to remember that arbitration, for many of its advantages, the disadvantage when you want to publicize something is that it's private. It's a private method, so you can't use it to advertise your dispute. There are other ways that communication can be used. One of the prime examples, what I would give as a tip for clients, is do not assume every single client thinks, I signed this contract, didn't care about how the progress of the project or the contract because no disputes are going to happen. Do not think like that. Always think there's going to be something. When you draft communication, even before there's a dispute, say on a construction project, just write it as if you know that a judge is going to be reading that letter. Don't go in and say, you son of a, so-and-so, you are awful. You know that when you commit that to writing, a judge is not going to like it because what you have is the written record, and communication is key even pre-dispute. So I would say it's very, very important.
So where does that fit in your range of skills? Obviously, a lawyer, knowledge of law is critical, but how you communicate that, is that just as important, would you say?
Yes, of course. Yeah. Tone as well as content.
Now, if I can move on to something a bit more interesting now, well, not more interesting, but more specific, which is the whole area of the emergence of states in areas where it still hasn't become a fully fledged state, hasn't become fully autonomous. These things go through a whole series of difficulties. Now, I understand you've been publishing on this subject, the whole idea of the emergence of states in an era when democracy is being challenged. Talk me through how you become involved in that, and perhaps give me an example of what it looks like.
So that was an interesting chapter. Yes, my chapter, thank you for drawing attention to it. It is in a book called Small States and International Law, published by Brill. It came out this month, came out recently. And how did I and my co-author, who is a policy professor at the Yale School of Government, get into that? Well, one day I was in New York, minding my own business. I get a call, and it's President Vit Jedlicka of Liberland, and he wanted an attorney general for his new state. He wanted me to be attorney general. And I said, hang on a second. I mean, I love my ego is flattered, but what state do you have? Is it recognized? Do you have a state? We entered into policy advisory, myself and Lauren Young. I brought her in. She's policy side, into, listen, you may have certain African states recognizing you in this territory you found on the banks of the Danube River between Croatia and Serbia, Liberland. and interesting case example to look into. But who of, say, the UN states, who has France, Germany, the UK, who has actually said, yes, you this unclaimed territory, very few in the world remaining, one of the few, is yours. And it was as a result of that policy advisory role that we were invited to write this chapter on, hang on, what is it? What does international law say about the creation of states, whether they're small or they're micro, and what do you need? And that's how we got into that. It was we declined. I said I'd love to be Attorney General, but right now I think we have to wait. And I think he's still in the process, and he's running.
Well, this is fascinating because it's not an area which gets an awful lot of profile in the media, for example. But there are, if you like, areas or states, for the want of a better word, which are not fully fledged, which are not recognised universally as states. And how does that process work? Does it go through international arbitration, a process of democracy? Perhaps it's different every time.
International laws. I mean, a good example is the current discourse around the recognition of Palestine as a state.
Well, absolutely.
And without going into the political background, recently the UK government has decided to recognise the state of Palestine. Now, to roll back and say, how does this work? The recognition of a state. One has to ask, what is the power of international law, and does it matter? International law, and I wrote an article about this in the context of the withdrawal from the certain agreements after Brexit by then Boris Johnson government. It really depends on cooperation between states. It cannot be enforced in a sense. It needs to be states in the world who decide, okay, we are going to act in a certain way, and we're going to commit this to paper. Some things are committed to paper, treaties, conventions. The UN Convention, obviously, everybody knows about, and the UN states, if they all come together and they say, we recognize, and based on, in Palestine's example, 1967 borders, this is the Palestinian state. This is, then that is one aspect. But one has to remember that there is no process by which it can be enforced. Nobody can go to arbitration and say, but you said this means you need to do this. Because international law is based on relations between states that diplomatically enforce them. So in our chapter, there are two methods. There's the constitutive method of statehood, and then there's the declaratory method. The constitutive method rests on saying recognition itself means that the state is the state. The more modern version is the declaratory method, which is based on the criteria under the Montevideo Convention of 1933, whereby there are four aspects to statehood. Defined borders, a population, and ability to enter into international relations, and effective governance. Those, basically, the declaratory method says it is a state, whether or not you put it to recognition is a facet, but it is a state de facto because elements exist. And one aspect is recognition. Well, one has to ask, but if all of the elements exist, but there is no recognition, is it a state? Or in the case of Palestine, recognition exists, but the other elements do not exist. What about territory? Is everybody decided on territory? What about governance? Can the UK government come in and say, yes, we accept that there's a Palestinian state, but Hamas cannot be the government? Is it in that position to say that? What if there's an election and the people choose to have Hamas govern it?
So there's a huge gap between international recognition of a state, or, for example, a government saying we are a state, a huge gap between that and reality.
Yes, and if you go back to one of the highest scholars known in the field, Lauterpacht, he would say recognition is a policy aspect. It is not law. We may talk about the law and how important it is, but as we have seen, the law is only important in as far as it's enforced. Recognition is a policy decision. So it remains to be seen by whom must these policy decisions be taken for it to be effective. And it goes back to Liberland, when Lauren and I sat down with Vit and said, but who has recognized you? Is it South Sudan, or is it the USA? There is a difference. So in a sense, one can go into an even more interesting question, which is, do we need a nation state? And has the nation state served us? Or do we have to, can we enforce international law within our communities? Because does that have more power than a nation state? And does that restrict us on many aspects? Freedom of speech, curtailment, all sorts of things. So there is this tussle between, okay, the nation state, and everybody's getting all patriotic, putting up flags everywhere. And then those who say, you know what, the nation state hasn't served us. And there are many examples currently of failing states, such as Lebanon, for instance. And where is there an effective governance? And what about Libya? Is there an effective governance? Who do we recognize? So it's a very, very complicated issue, but it is solved by self-serving interests in a sense. And
so how do you, if you're brought in to advise on this as a lawyer, for example, Libya, for example, where a number of different tribes and factions and militias and the Tripoli government and the Benghazi government, but all combined to overcome Gaddafi. But then once that had happened, they're completely at odds with each other, which is one of the reasons the state hasn't emerged. How can you begin to overcome those challenges?
I mean, it's a big question. Again, I'm not an expert on Libya. I can say that where I'm from, Iraq, there's a tension between the semi-autonomous region of Kurdistan and central Iraq. And I guess my advice to those wishing to do business in Iraq is to have in mind that although a region may give the impression that it's open for business and that it's modern, such as, for instance, Kurdistan gives, it does not mean that it can then be held liable on the international level when certain defaults are committed. Because what investors will do is turn to statehood to understand that actually it is not a state. It's the government of Iraq that it must go to raise disputes. And the problem with that is if you didn't contract with the government of Iraq, they will put up their hands and say, well, we are not involved in this, or we don't have. So it becomes a batting the ball type thing. In terms of Libya, who are the most powerful actors behind the recognition of, say, of a certain faction? And you kind of have to hope that when you do, it should be doing business with, say, for instance, in Libya, it could be the UN-recognized government.
In Tripoli.
Yes. And you've got to look at other aspects, such as how do you enforce certain aspects of your transaction, SWIFT system, US dollar currency, transfer of funds. All of this is a network. Do I go to the UN-backed government in Tripoli, or do I go with a tribe that actually has more physical power on the ground? When you make that decision, you have to hope that situation continues. For instance, in Kurdistan, those in power change. The different people and factions change. They may decide they don't want to do business with you. If you go to an actor which is held to account, such as a government which receives funding from the World Bank, from international institutions which cannot afford, again, we come back to reputation, it cannot afford to have its international reputation ruined because these actors recognize it, and if it acts badly, then that, gets thrown away. Then I would advise that you maybe look beyond what's maybe the most lucrative business transaction and go towards the safest of the positions you can go towards. Negotiate with a government that is recognized. But bear in mind, reward comes with risk. Isn't it better to do transactions in Switzerland?
You clearly work with state entities. How important is reputation for those entities, and how do you get involved in that as a lawyer?
Yes, I work with states and state entities. I sue them. I have 3 cases against them, and I've represented them as well. I've represented my government as well. Certain states do care about their reputation, and certain ones don't. It really depends on the situation, and it interacts with business and geopolitical considerations at the time. I have a dispute that relates to a Central African state, which hitherto was not as important as it now is in the geopolitical aspect, because it has now got strong relations with the UAE and in relation to other conflicts that are happening in the region. It also requires funding on the international level. That state against whom my client has a judgment to enforce could be very embarrassed if it came out that they can't meet this judgment. It relates to meet the enforcement of the judgment. It relates to the upgrading of telecoms equipment to 5G, and it's in partnership with Chinese entities that the state wants to do. My client, who was the 2G provider, hasn't been paid for his 2G services. So how embarrassing does that look? Yes, in that instance, I would say now is the time to put pressure because this state would care about its reputation. On the other hand, there are certain Gulf states and other states, but I'm just talking from experience, that wouldn't really have as who wouldn't, let's say, worry so much about what the international community would say or do if they didn't pay a certain investor. And possibly that's because the cards they hold are quite strong. They could be oil rich. And they may be the ones dictating the terms to the international community. You won't get our oil unless you do this. So why would they care as much? So you've got to see when a state cares about its reputation, who controls the purse strings behind the funding that goes to that state, and then you play on those.
It sounds like in these kinds of disputes, there are a number of different levers to pull. I mean, it could be you rely on international law. But I would imagine that only takes you so far in some jurisdictions, or you rely on financial clout and firepower and recognition by international financial institutions. Am I right? You have to play with all these different levers?
Yes, and one of my fields is investor-state arbitration. So there is such a thing as bilateral investment treaties, and this came about in the many years ago, in the 1950s, I think. And also in the aftermath of the post-colonialist project, the Washington Convention came out, the ICSID Convention, pursuant to which investors are able to unlock swinging, like they are able to, sorry, I'm going to rephrase.
Okay, no, let's go again there.
Pursuant to which investors are able to use bilateral treaties concluded between states, host states, to unlock benefits that are afforded to investors of investors coming from these states. So if I have a case in which an American investor is suing a Middle Eastern state, and under the treaty between the U.S. and this state, he has rights that local people in the Middle Eastern state do not have because he's a foreign investor. So using those treaties and the law is very powerful. At the same time, you could get an award at the end of this, whereby a tribunal says, yes, you investor have been wronged underneath these clauses which have been breached by the state, which enable you to recover a large amount of damages. The next stage is enforcement. Go ahead and try and get that state to pay. That is the next stage. Many firms are very good at the arbitration process, but they don't have a clue about how to go about and actually enforce, because it comes on to your second point, which is how about what about non-legal routes that you need to employ? And it's in the enforcement stage that you need to draw on geopolitical considerations, financial leverage, people on the ground, networks. Again, going back to people, relationships, leverage those pressure points, and that's not a legal issue. And that is something that a lot of firms don't know how to do, even though they say they do. There are few firms who are enforcement specialists, and you need to work with investigators. You need to work with PR and communications firms, such as SLA. You need to work as a team on enforcement, and for me, that is the exciting stage. It is enforcement. It's getting to the money.
So what have you learnt about the application of statehood? So once arbitration has been achieved, how do you make sure that then becomes reality?
I've always been interested in people. So people ask me, how is it that, you get these certain really interesting cases and the clients? I said, well, if I'm in a lift, I will speak to somebody, even if it's for 5 minutes. I mean, I'm interested in people, and I'm interested in stories, and that comes back to my writing. I loved the story, the narrative, the story. What is this? If it's a compelling story, and I can tell a compelling story, and I'm a good writer. And so the qualities that you need are to be a good people person. You need to be a good listener, and you need to be open and not have specifically rigid defined views, because I don't think you can then kind of attract the different people and get them to open up to you if you're not open yourself. And I think you need to not be fully motivated by just economics, because some of the most rewarding things that I have done haven't really brought me anything except for satisfaction on a non-economic aspect. And I'll give an example. I was approached by through their lawyer. Actually, he did work on the Libyan terrorism, the Pan Am disaster, from a legal perspective for the U.S. Government, and his clients, Dr. Alan Gerson, he's sadly passed away, were the heirs of the Morozov collectors and if one knows about Shukin and the Morozovs, they collected a huge collection of impressionist art, Russians. So that Morozov heirs, the Konowalovs, destitute, living in Paris. Sorry, I'm going to go back. I'm not going to say destitute. Okay. So the Konowalovs, living in Paris, believed that they had a right to Van Gogh and many other highly important impressionist works currently in the Hermitage. They had no legal route, and so Alan and I had a discussion of how can we help these people, because these artworks, which are at the center of their dispute with Yale University, who had one of them, and then effectively the Hermitage, is they don't have a legal... In St. Petersburg, which I visited. Beautiful, amazing collection. They had no legal route because this work was taken back in the 1917 Bolshevik Revolution. And so basically to go and challenge this in the courts, forget being out of time, you're challenging an active state. And it is not the same category as the Nazi looted art, for which certain legislation has been passed in the US where this would be false. So no legal avenue. What do we do? Well, let's rely on a non-legal avenue. In order for any institution to show these works, which would bring monetary gain to the owners, they need to not show it saying they cannot have these works shown in an exhibition and say these are our works, because they would be a fuss caused by these so-called the rightful owners, and it wouldn't be a press look good in press. So what if we came to an agreement whereby the Konowalovs would be recognized in an exhibition, and they would be provided with some royalty rights that came out of an exhibition, as long as they renounced any further claim that they had to the actual works. So working together with the Art Loss Register, we, and especially a lot of credit goes to the Art Loss Register here, came up with a solution, which was to have a big exhibition, which was the Morozov exhibition in Paris at the Louis Vuitton Foundation, which is an exhibition I went to, many people went to, beautiful. And in return, we had these assurances that there would be certain recognition given to those who once owned the works, and that they would have a certain amount of the royalties. And so not many people know that wouldn't have happened if we hadn't come to that deal. And that didn't really provide any of us on that team with, financial, didn't make us rich or anything, but it gave us it gave me a satisfaction that we brought together this exhibition, and we found a solution that may not be the best thing, that the best solution that the Konowalovs would have wanted, but it was a solution that enabled a wonderful collection of art to be shown to the world.
And that went beyond the financial aspects of art to a much more esoteric one, and also involved you thinking outside the box, lateral thinking, coming up with a different solution than the one that was originally sought. Is that what it's all about in many cases?
Yes, because a lot of people want to prove a point and do the thing that, another art collector client I had wanted to sue a fraudster who went off with his Warhol work. It's a public case, the Gulbenkian case. It was a Gulbenkian member of family and very prominent. And no, we must go and, Gulbenkian owned not the family, this member who had married into the family. Owed a lot because still took a lot of works, and was being sued. But then I said to my client, why are we doing that? Because you are going to be ending up spending so much money going around the world, and fraudsters are very good hiding their assets and putting them in companies and structures, and why don't you go to the enabler? Because under English law, there is a tort of conversion, which is any handler of a stolen work that entity itself would be liable under the tort of conversion for selling, for handling, for being in possession of a work that was illegally obtained. And so that we went after the gallery and said, look, if you don't pay up, we have an action against you. You have to settle this. We don't. We know that you didn't know this was stolen, but still, under the law, that doesn't protect you. They were concerned because they're bricks and mortar London gallery. They're concerned about their reputation, so they paid up. And so my client got a settlement. What they did then and whether they pursued Gulbenkian is not our concern. But my concern was more, how do we end this for the client in a clean way that doesn't involve throwing lots of money at it and going around the globe following this fraudster?
So you've clearly become involved in a really interesting and very complex area of law. What's next for Kadhims?
I go by the Soviet kind of motto of we don't know what's around the corner, so we live in the moment and hope for the best. But no, to take it, I guess, what I want to continue doing is to be working with people, not brands, not, this is how Kadhims has worked, to grow organically and to work with people and teams whom I respect on disputes. I think there will be more of a focus on the non-legal solutions. I think we're coming into a world where communications and relationships matter. I think we are in a world where it can be quite frightening with how much we are owned by our digital footprints and our digital accessories. And I think I would like Kadhims to stay in this real world where we have real meetings, real relationships, leave the phone at home, speak to clients in the bar or the restaurant about their problems, and I don't think in that way Kadhims will change, but I think that as the world becomes more complex, I would seek to make Kadhims simplify it more, and that's the motto of Kadhims: simply resolve.
Perhaps we can finish, because of all your experience in this area, looking at the bigger picture, if you like. We've seen, as a result of Ukraine, a certain amount of polarization between East and West. And we've seen the BRICS nations, Brazil, Russia, India, China, South Africa, in some ways coming together as a response to what's happened. And, for example, Russia and China meeting, India meeting. Is that how you see it? And how concerned are you that we are seeing, if you like, a polarization of nations rather than a bringing together of them?
I mean, I think that's what the hegemonic powers would want you to believe, such as the US, which was behind the unipolar world. One has to be careful of what information we receive and where it comes from, because that is the say maybe an American way to look at it is that we are important. So this anyone who is not our, as Jeffrey Sachs would say, and said in his address to the European Parliament in November, anyone who is not our friend is our enemy. That is not the position I think China or Brazil or Russia take. I don't think there is this view of, you're either with us or you're against us. I think we are moving more towards a position of neutrality, and one is not ashamed to be neutral rather than taking a position and saying we're going to be polarized because we think this way, we don't, black or white. I think that China and Russia and Brazil and the BRICS countries and the expanding BRICS countries come at the future more from a perspective of working together like grown-ups. In an era where trade is important and where diplomacy matters. So I think diplomacy has died, that it's now we hope will be revived, because right now we don't have effective leaders. So I think that rather than look at it from a perspective of polarization, I think the BRICS countries are looking at it more from a perspective of how do we work together in our economic and financial interests, even if we don't agree with each other. So Orban may meet with Xi Jinping or Turkey's Erdogan, and they may not agree on political issues. I mean, communism and socialism and aside, we do agree that we want to work with each other and trade. And I think it would be an absolute mistake for Europe to take a stance that is contrary to that and to say, because of our stance on the war, we've dug ourselves into this trench, and even if it harms us and our trade, I think that would be foolish, as Jeffrey Sachs also said. So again, I'm quoting him a lot, but he's pretty authoritative on this. In the sense that we need to work together and put aside our differences. So I don't think it will be towards polarization, but more towards working together.
So you talk about the importance of democracy, but how important is international law in establishing the principles of statehood?
I do think it is important. And I think that, to give an example, to go back to the statehood recognition aspect, there's a debate as to, is this actually effective? If you are recognizing a state, but at the same time enabling its destruction, physical de facto destruction, is that actually important? And I would argue that rather than look at the self-interested motives of using international law, let's not look at the motives, because it will always be used in self-interested ways by governments. Let's look at the outcome. The fact that you, on paper, recognize a state of Palestine will have implications long after, as I say, like Ozymandias, we are long gone. I don't know if you know the poem by Shelley, but we all become dust. What's left is what's on the paper. Imagine if Gorbachev had insisted on the promises by Baker, that Secretary Baker of the US, that NATO would not expand 1 inch eastward. He relied on words. If that had been written down into international legal instrument. Now, we all say, and many commentators say, it doesn't matter because those were promises. Promises are intended to be binding. That's what they are. But if they had been, say, reduced to the level of a treaty, to be included in an international law treaty, would that not facilitate the Russian argument now to say this is what the international law position is and give them a stronger status? We will never know. But all I can say is that it is better to have international law and to have these written binding statements that we can hold people to account to, or the generations that we give birth to can hold people to account to long after they are gone, long after the people who promised them or said them disingenuously are gone. So I do think that in that sense, international law is and will always matter.
Noor Kadhim, thank you.
Thank you very much.